everyone. Welcome back to our series Legalese Translator. My name is Heather Hoyletun, and with me here is Heather Douglas. Hi, Heather.
Hi.
In this video, we're going to continue to talk about costs in civil litigation. Don't forget to check our previous videos on costs by clicking on the little button above, and I will also have these links in the description below. So let's move on to talk about the phrase cost consequences. You may have heard lawyers, sometimes they mention that there will be cost consequences if parties refuse to settle, or you may have heard of what's called Rule 49 offers. So Heather, could you explain to us just what that's all about?
Rule 49 sets out all these rules about offers to settle and what happens when you don't accept an offer to settle. And it also lets us know how to make an effective offer to settle. So when you refer to a cost consequence, that's really in reference to whether you accepted or rejected an offer to settle. When you go to trial and you get a judgment and you get more money, as if you're the plaintiff and you get more money than your offer to settle, then the cost consequences are likely going to be in your favor. And that's because the rules set that out. And if you look at Rule 49.10, that is the one that has the exact details about what it means. So if you're the plaintiff and you offer to settle your case for $500,000, but the judge says, you know what, you get $700,000, then you're going to get your costs, so what you paid your lawyer and the disbursements, you're going to get that at a higher percentage recovered from the other side. And that time, when you get the higher amount, which we refer to as substantial indemnity, starts ticking from the date that you served your offer to settle. So from the time before your offer to settle, you're going to get your costs reimbursed, hopefully, at a partial indemnity rate. And then after, it's substantial indemnity.
It says that the offer has to be made by the plaintiff at least 7 days before the commencement of the hearing. Do you want to do a little comment on that?
Yeah, so it's not just any offer that's going to trigger these cost consequences. The offer should be in writing, and it also should be made at least 7 days before your trial begins. So to be on the safe side, try to do it way before the 7 days. And a lot of lawyers will serve an offer to settle as early as they think is strategically possible, because that gives them more time to have the costs recovered on a substantial indemnity basis.
Now, what about, I'm looking at Rule 49, the last part, the paragraph underneath Part C. And there's the rule says that at the very last sentence here, and substantial indemnity costs from that date. So does this mean that the cost at the higher amount that you mentioned, like it doesn't cover the cost for enforcement by your lawyer?
Usually it refers to the costs from the date the offer was served until the date of your judgment. But it's always in the discretion of the court to determine how they want costs to be awarded and for what time period they're going to award it. But usually the enforcement of the judgment is dealt with separate.
I see. And now I noticed that, of course, there's a second part to Rule 49.10, and that has to do with the defendant's offer. So I've pulled up here the defendant's offer, which is 49.10 sub 2. So could you explain to us a little bit what happens if the plaintiff does not accept a defendant's offer to settle?
Yeah, so the cost consequences for accepting an offer to settle are not symmetrical between the plaintiff and the defendant.
Okay.
So if the plaintiff rejects an offer to settle, let's say the defendant said, I'll give you $500,000. And at trial, the plaintiff gets $300,000, then they're going to have to pay the defendant some of their costs of the proceeding. And that's going to be from the date that the defendant served the offer to settle. They have to pay the defendant's partial indemnity costs from the date of the offer to settle to the end of the trial. Alternatively, at the same time, up to that date of the offer to settle, the plaintiff will get their partial indemnity. So you're going to have both sides are going to get they should get some recovery under the rules. Of course, that's in the discretion of the court. But that offer to settle date, the date it was served, is really pivotal to determining when the defendant gets to recover their partial indemnity costs.
This is really interesting, this part, because it means that if I were the plaintiff and I won, it could still be possible that I have to end up paying my opponent some of their legal fees as well, due to this offer to settle, this warrant offer to settle.
Exactly. So even if you've won some money,
Yeah.
you still might be at risk, because if it's not as much as you were previously offered in writing,
Yeah.
and that offer to settle was still open at the time that you went to trial, then it can be really burdensome financially for the plaintiff.
Right, yes.